thank you to everyone for joining us here today, and thanks to the wonderful organizers for putting together this event. I am delighted to be here. Without further ado, we will jump in. So on Stu's theme of starting to build kind of standards and common standards, we are planning to start with a question for Megan and then Chelsea to begin building a vocabulary for the rest of the day. So I would appreciate if you could talk a little bit about how do we define scraping sort of as an activity neutrally, and then within that, how do we define unauthorized scraping? So maybe thinking about the US first, Megan, we turn it over to you to kind of share, are there any legal or generally accepted definitions for what is scraping, then what is unauthorized scraping?
Well, considering that in the US there aren't any specific scraping laws, but there are scraping, I would categorize that there are actually a few subcategories. One is web scraping, and that's the collection of data, usually through the HTML of websites through crawlers, scrapers, pieces of code. Another type is screen scraping, where the contents of a screen is captured, and that could be done, it could be done either through public websites or by taking login credentials and going in and taking data that way.
Great, thank you. So you described the activity, and we established there are no sort of settled legal definitions in the US at all. Chelsea, what about internationally? I know you've been looking into this. If we look outside the borders of the US, do we see any legal or accepted definitions of what is scraping and what is unauthorized?
So first to note on the authorized versus unauthorized. So there's certainly authorized scraping, and you can have scraping for many different purposes. Our focus today, I believe, is on unauthorized scraping, and I think there's a real question of what is authorized versus not. And companies who sit on platforms can define those activities differently. But similar to the US, internationally, there is no real legal definition around web scraping. There are no laws, generally speaking, that govern this type of activity. But we are starting to see in some of the Asian countries like South Korea think through this issue a bit more, but we've not gotten to a place where generally there are clear distinctions with unauthorized scraping in international law. I think something interesting about this issue is we're talking about different jurisdictions, but it is a global conversation. So when it comes to the internet, it's very difficult to have physical jurisdictional boundaries. If you look at the rise of the internet and you see country A does things a certain way, country B does things a certain way, and so you see actors going to country A in order to do certain activities, and you're starting to see that issue with web scraping as well. So part of addressing this is just having the global conversation and recognizing that these can't all be separate issues that every country addresses individually. One more note I'll say on that is, as the US is making decisions about how to treat web scraping, you have countries that are actually watching what the US is doing to figure out how they want to address it as well. So one example of that is Australia and New Zealand. So they oftentimes look to the US for how they interpret decisions. One example is in the contract space. There's court decisions on how the US discusses contracts, and then applied to the web scraping context, if we're thinking of terms of service and what's unauthorized and what's authorized, they're thinking about these issues in the same way. And the way that we know this is they're actually citing US opinions in their own court cases for how they're thinking about the issues. So I think it's interesting on how the US is affecting the rest of the world in that way.
Very interesting. Thanks, Chelsea. And then again, just kind of to round out this theme of, common vocabulary, making sure we're all thinking of the same things. Megan, I'll turn back to you just briefly. Are there any kind of common misunderstandings that people in this room or online might have about scraping that we might want to address right at the beginning? Any distinction between what you defined as scraping and, for example, like, a hack or a data breach or, other types of events that could happen that could affect data?
I mean, there are numerous types of unauthorized collection of data, and I think one thing that's kind of useful is seeing web scraping and other types of scraping as subcategories of that unauthorized collection of data that result in very similar types of harms, like autonomy harms.
And through those very technical means that you mentioned at the beginning. So it just occurs to me that's also something we should have in mind, is that this is a very automated process, right? Great, thank you. So now we'll talk for a bit about the legal landscape of scraping. What is it? What could it be, et cetera? So Cobun, I'll start with you and then come back around to Tim. So in terms of the legal landscape, I think we can think of scraping as potentially triggering a lot of different areas of law, right? Stu mentioned privacy, the second panel will drill down on that. There's some other legal issues that also could potentially be raised by this activity, right? Could you maybe give the group just kind of an overview of the different types of legal issues or policy issues that could be raised by scraping?
Certainly, I can certainly take a stab at least. And thank you again for having me. This is wonderful. I'm excited to focus on this issue today. And I'm a privacy person. I'm pretty much a generalist. So my love is on the privacy side, but yeah, this is a fascinating issue because it really doesn't fit very neatly into any legal buckets. I think and I think courts, you've seen that throughout through the history of the internet, the courts have struggled with trying to approach this in different ways, whether that's through property type rights, through contract, through torts. It touches on all of those things, and it doesn't quite fit with traditional aspects of common law in those areas. We will probably hear a lot today about the Computer Fraud and Abuse Act, the CFAA, which kind of arises from property. It's about cyber trespass, and as we'll talk about later, I think we found that it certainly doesn't quite, at least according to the Ninth Circuit, and the way that things have evolved, that doesn't quite incorporate what we're an actual remedy for scraping. I found that the case in the Ninth Circuit, the High Q case versus LinkedIn, is actually, I was reviewing that again today, and I found it interesting because they kind of the court actually lists a number of potential other avenues for redress around the types of harms that you see in scraping. And so I thought I would just list those for you now, just to kind of set the table. And I think Tim might have other things or his own approach here to help us conceptualize this. But they list trespass to chattels as kind of the traditional trespass element, copyright infringement, misappropriation, like trade secrets, unjust enrichment, conversion, breach of contract, and then privacy. And some of these are tried and have been tested in court. Some of these have been less tested, but we're sort of still seeing that evolving in the US and elsewhere. I would also point just to the fact that there's multiple interests at stake when it comes to scraping. Stu's remarks talked about user data. There's this question of what interests users, consumers, people that have created content that's sitting on platforms, what interests they have, and whether they have remedies against people who are scraping, and then also the interests that the platforms themselves have. And those sometimes overlap and sometimes are distinct, but that's the big questions that we have that we're trying to solve here.
Right, the topic for today. Thanks, that was really interesting. So Tim, turning to you, we can hear that this is a challenge in search of a legal framework, right? Can you maybe take us back a little bit and talk about where the legal, landscape is today? Obviously, I think everybody in the room probably knows there have been some recent major cases, but how would you describe this legal landscape of scraping today?
Sure, thanks a lot. I'm Tim Edgar. I teach law and cybersecurity at Brown University and also at Harvard Law School. We have an online master's at Brown University, which I need to plug here. And one of our students in the room who is one of our great students in that program. One of the things I do in that program is I look at a variety of legal frameworks. I tell my students, the thing I love about cybersecurity and privacy is it's great for somebody who has a little bit of ADD or just wants to always go back and forth between different legal frameworks, because there you go. You've got your everything from the law of war to regulations of various kinds and everything in between. Unauthorized scraping is no different. Unauthorized scraping, we heard, I think, very, very well described by Megan, and it's just, I think it comes from, backing up for a minute, the internet was not built with security in mind. Those who architected some of these protocols and standards, they thought all you had to do to avoid someone who wants to do web scraping from scraping your website is to put in a little tiny string of code, robots.txt, and then, of course, when the program sees that, it won't scrape it. And of course, that works fine if everyone's cooperating. If everyone's part of a kind of academic, cultural endeavor of the internet, which is, of course, how it started. So it really wasn't that crazy an idea. We have two principal frameworks that I think about with unauthorized scraping. One is hacking law, and the other is privacy law. So I'll just talk very briefly about that because I know you're going to hear about both of them in a lot of detail. The one we've heard most about in the courts has been hacking law, the Computer Fraud and Abuse Act, the principal federal anti-hacking statute. And what that does is it criminalizes, it makes it a crime to either engage in unauthorized access to a computer or information system, computer system, or to exceed authorized access. Those terms are not defined in the law. Those terms date back to 1984 when the statute was originally passed, but actually they're good terms. They're meaningful terms in computer science. In the case the Supreme Court heard involving a different prong, involving the exceeding authorized access part, in an opinion written by Justice Amy Coney Barrett, I think she took a very good approach of saying we should really look at that term of authorization from a computer science standpoint. This was a huge insight because for literally decades, the courts had struggled with the term authorization because judges are lawyers, trained as lawyers. So are lawyers appearing before judges, obviously. And authorization, and authorize, these are words authority, these are words we think of in terms of the law. But they're also terms used in computer science and in computer architecting computer systems, and they have a distinct and different meaning in those contexts. And essentially what she said in her opinion is authorized should be given a technical meaning because it's a technical statute. In the case she was dealing with, it was a police officer who abused his access to a database. He was authorized to use the database. He did not exceed the authorized areas of the database. He just abused his access. He misused the data horribly in a terrible series of facts. So she said that's not a violation of the CFAA. Maybe there are other crimes, but that's not the crime of hacking. A police officer who logs onto a database, misuses the data is not a hacker. Okay, so LinkedIn and HiQ come along. HiQ is a startup that scrapes LinkedIn's data. It's publicly available data. LinkedIn has put a robots.txt, we don't want you to scrape us, little request in their text. They ignore it. Then LinkedIn does various technical means to try to block their access. They ignore those too and try to circumvent them. So here's the day. Is that accessing the information in an unauthorized manner? It was going to go to the Supreme Court, and I have to say I was really annoyed when the Supreme Court agreed to hear that case. Great, fantastic. We're going to get more guidance on what the CFAA means. Another case with different facts about the CFAA, that's what we need. And instead of hearing a second CFAA case for the first time in 40 years, they remanded it to the Ninth Circuit and said, we already decided a CFAA case. Look at our opinion in that one. Give us an answer. And I think they genuinely thought that their decision in that case, or at least some of their clerks or justices thought, yeah, it's obvious what the answer is from our case in this case involving the police officer. I don't think it was obvious at all. It was a different part of the statute. It involved different issues. But the Ninth Circuit looked at it and essentially said, well, if you need to be authenticated first, before we then look at whether you're authorized to use data, here you have public data. There's no authentication in one sense, and I don't want to dominate, so I'll get into authentication in a second if you want me to. So therefore, there's no CFAA violation. I think that was too hasty, I would say, on a legal rate. The other rule, and I'm not going to get into too much detail on, is privacy law. And I think no matter which side you fall on the CFAA issue or the hacking issue, many commentators, many privacy groups who hate the CFA, want a very narrow interpretation of the CFAA, reluctantly may agree with HiQ because they just don't want the CFAA to be too broad, would say, well, this shows why we need a comprehensive data privacy protection law in the United States, because there are so many areas of private data where using our criminal hacking statute could create all sorts of problems, but we don't want to leave the data completely unprotected like it's the Wild West. Just because it's not a crime to go and do certain things with data on the internet doesn't mean that the law shouldn't regulate it, or at least give a civil remedy to companies or organizations who are dealing with, a company that's actually trying to exploit that data. Maybe we don't want to put them in prison. Maybe we don't want to say they're hackers. That doesn't mean that we want to validate their business model of exploiting personal data. So with that, I'll close.
Thank you.
Yeah,
That was very...
it's a danger. I'm used to, 40, 90-minute lectures. So that was actually pretty short. So.
Well, it's great to have a master class in it. So thank you for the recap of the recent law. And I'm glad we got that out right at the beginning, because obviously those have been some major legal developments recently that it's good to have that framework in mind right at the start of the event. And so, you shared how there have been kind of recent happenings. What are we watching now? So Megan, maybe I'll turn to you. Are there any cases kind of on the horizon that might help to cut through some of this? Or, is it kind of like the world of scraping and legal is paused right now, waiting to see what happens next? Or what kind of things are you tracking?
I'm not personally aware of any additional CFAA cases. We were involved in the HiQ case from the first time it was in the Ninth Circuit, when the injunction requiring LinkedIn to give HiQ access to its user data was being appealed, and we got involved because the balance of the equities analysis was a little bit wonky there, because the court below, the district court, decided that HiQ's business interests outweighed the privacy interests in user data without actually doing any kind of analysis of the privacy interests in the user data. But given the Van Buren decision, given the latest HiQ decision in the Ninth Circuit, the CFAA does not seem like a great way to deal with scraping. What we really need, as has been mentioned, is a privacy law that would deal with it. And this past year, we saw a comprehensive privacy law introduced in Congress. A great deal, the most work that has been done on a comprehensive law in decades. And what was the main, one of the biggest carve-outs was for publicly available information. And this is a constant issue with trying to get scraping included in comprehensive privacy laws, or any kind of privacy law, and that is the immediate gut reaction that there's a First Amendment issue here. And that has yet to be sufficiently challenged. Certain groups pretty much go to Congress and say this is a problem, so we can't do anything about it. But I think what's interesting here that I'll point out, it's not CFAA cases or anything, but some recent First Amendment challenges to privacy statutes, such as non-consensual pornography statutes, that have actually prevailed even under strict scrutiny, because the privacy interests are so great. And I believe that the same thing could be said for any kind of privacy statute that would try to regulate scraping. And that is because particular the recent case of Clearview AI and a whole bunch of other AI companies that are essentially just scraping everybody's personal information off the internet to feed into their machine learning tools. Now, there again is the immediate autonomy harm of collecting someone's information and taking away their choice as to whether that stays on the internet and how it stays on the internet and who has access to that information. And then an abundance of downstream harms from the subsequent use of that information to create facial recognition profiles and to make other harmful inferences about people. And if that can't First Amendment scrutiny, like what can? So I think it's time to challenge that assumption that we can't have laws that regulate this.
Mm-hmm. Yeah, so you would prefer, coming to one of our next questions, you would prefer for the legal framework to make clear distinctions between permitted data collection and then unauthorized scraping. And in particular, you spoke about how that should apply to data that is publicly available and that shouldn't, in your view, it shouldn't be the dividing line. I'd be interested to hear what others think about that. Should we have some kind of a statutory framework that's clearer here and that defines the authorized line versus the unauthorized line? Is it time for that? Anyone? And Chelsea, maybe you have insights from overseas, that you maybe have insights from your international research or the US.
Back to what you were saying about some of the other legal issues here. So for unauthorized web scrapers who are using the data in nefarious ways, I think there are a lot of other issues to bring up for enforcing against these types of actors. One issue is the logged out versus the logged in ways. So unauthorized scrapers who are using the data in bad ways, they're becoming a lot more smart about how they're getting this data. So they're logged out while they're scraping it. It makes it a lot harder to enforce via terms of service or other mechanisms against them. So I think that's something that's a challenge right now with unauthorized scraping. The other is the consumer harm here. Proving harm. If there's proof of how the scraper uses the data, especially for fraudulent means, or if there's a privacy violation hook, it's a little bit easier to try and argue that it's for, there's a web scraping claim there for unauthorized access. But part of the difficulty is that the data gets mixed. And so it's hard to prove consumer harm with data mixed coming from different sources and knowing really where the harm lies there. Part of the other issue internationally is that, like the US, there's no clear web scraping laws. And so companies are trying to figure out, how do we fit this into categories? Is it the breach laws? Is it consumer harm laws? Is it property laws? And that's been very difficult to do because there is no clear tie into those for many of the international jurisdictions. We're seeing in some of the Asian countries, specifically in Thailand and India, there's many laws around computer crimes. But that gets a little bit harder to tie it into unauthorized web scraping because it's difficult to know how people are using the data. If it's for fraudulent means, are they, like I said, the logged out versus logged in, how are they getting it? Where is it going? So the harm piece there really makes it difficult internationally as well.
Thank you. Very interesting. And we'll talk more sort of in another, in our next phase of the session about like maybe what the law should be. But in the meantime, I would be interested to hear Tim or others, if you want to jump in, today, right, in the absence of a further law being enacted yet, what are the alternative legal grounds that could emerge, right, to address unauthorized scraping?
Well, we heard a little bit about other theories of liability. My own view is that the CFA is still kind of a live issue, despite what the Ninth Circuit said, precisely because the distinct facts are actually quite different from Van Buren versus United States. That's a Supreme Court case. Van Buren was about exceeding authorized access. This is a case about accessing without authorization. So it's actually a different part of the CFAA. Also, the idea in Van Buren was look at the word authorization from a technical standpoint. And the question is, does the person who's being authorized, have they been given the right to go into folder A, or folder B. I think it was X or Y, actually. And if they've been given that right, we're not going to look at the way they abused their terms of service or something like that. That was essentially the insight. You know, basically from a technical perspective, when we're talking about authorization, that's a fundamental part of computer security or cybersecurity. And we usually think of them as the 3 A's. We think about authentication, we think about authorization, we think about access control. And the CFA is kind of strange because it never uses the word authentication. It only uses the word authorization, and it also talks about exceeding authorized access, which kind of seems like access control. So I think the Ninth Circuit made a huge leap of assumption that what Van Buren was saying was, if there's no authentication gate, it's fair game, everything applies, there's never a CFAA violation. But the Van Buren court said nothing of the kind. And I was sort of curious about this issue. I quizzed a number of my colleagues who are more technical than I am, although I do have the lofty title of professor of the practice of computer science now, which, you know, is interesting when your only degree is a JD. But I quizzed them because I thought, well, surely there's an answer, a technical answer to this obvious question of, you know, is authorization something that you only ever talk about before authentication happens? First of all, there is not a clear technical answer to that question. If you look at various technical manuals, some of them seem to apply that, some don't. But the second point is that authentication is much more complex than username or password, or, you know, you are who you say you are. Those are nice shorthands, but authentication refers to basically a whole series of steps that a computer uses to decide whether to grant access. And to be authenticated, it might mean, okay, I've told you who I am, I have an account, but it could also mean I've showed you that I have a particular token, but you still don't know who I am. Or it could show you, I've shown you a whole bunch of characteristics of who I am, now authenticate me. And many of those techniques were techniques LinkedIn was using to prevent scraping. Those techniques could be determined by most, I would say maybe all computer science researchers would say, those are authentication steps that were being taken. So I think the Ninth Circuit kind of just breezed right through this and said authentication means publicly available data is fair game. That is not what it means at all from a technical standpoint. And if we look at what the Supreme Court said about how to read the CFAA, we're supposed to read it through a technical lens. So I do think that the legal issues here are more uncertain. Maybe in a future scraping case, maybe in a different circuit, we might end up with a circuit split. And who knows, by 2055 or 2065, we might have an answer from the Supreme Court about the circuit split, given the general pace at which these things go. So that's my sense about the legal issues there. Just in terms of the policy issues, just quickly, I do think that one of the big problems lawyers have and judges have is they hear the term privacy and their brain shuts down and immediately goes to the Fourth Amendment. And they say, aha, privacy, I know what this is. It's cats, it's reasonable expectation of privacy. It's what the police, what do you need when the police need a warrant to get something? Well, obviously, publicly available data, what you're doing in public streets, there's an enormous host of things the police don't need a warrant to do when they're engaged in an investigation. That does not mean that the law can't and doesn't already regulate many of those activities. Many are highly intrusive. Many involve serious invasions of privacy. That's why the police have extensive investigative guidelines. J. Edgar Hoover, I've been reading his fabulous new biography. So many of his files were basically publicly available information, aggregated in a way that was deeply revealing. So the law, just when you hear the word privacy, don't immediately jump to the Fourth Amendment. There's so many areas of law and so many privacy interests that are implicated by aggregation of publicly available information, especially on the internet, especially in 2023.
Yeah, and that ties directly to what Megan was saying about publicly available information, because the argument goes that if it's public, then you have no reasonable expectation, right? You've put it out there on the internet somewhere, and so therefore everywhere is fair game. And that goes against a lot of what we've learned about how privacy works, how people's expectations of privacy are informed and the kinds of harms that can flow from data being shared in ways that aren't expected. The privacy is deeply contextual, right? So one of the potential harms from these types of technologies when we're thinking about use cases, and it will probably, I'm sure other panels will go deeper into some of these recent use cases, including Clearview AI, but also generative AI like ChatGPT, which is in all of the news right now, maybe less so concerned with personal data, but still scraping lots of data from everywhere. One of the big risks is that it's something that decontextualizes information, right? It takes something from one context that's been shared in a very specific context, like a LinkedIn professional profile, and enables that to be used for matching, in the Clearview example, matching faces that may be anywhere else on the internet. That is something that kind of goes against the way that humans think of their interactions with the world. It's not, it goes beyond, and that's, I think, why we start to wonder about that in the privacy context. However, as we're thinking about privacy laws coming along to save the day, it's really important to consider what Megan said, which is that there's generally, in most data privacy laws, a publicly available exception. And until we change that conception, it's unlikely that privacy is able to, the data privacy laws are going to be able to address some of these issues.
Yeah, that kind of brings us directly to the question of, what should happen next, right? So CFAA is an imperfect fit. Privacy law today can be an imperfect fit, even though we've talked about what privacy interests can come up in the context of scraping. So what is or what should be the role of government, both regulators, policymakers, maybe even in their enforcement role? So it's kind of a question for the panel. What could the role of government authorities be in combating unauthorized scraping? We've seen various private litigation, right? IQ versus LinkedIn, other examples, many other examples, right? What could the government be doing right now? Is it mostly, would be looking for passage of a law, or are there other things that authorities could be doing or should be doing right now to help define and combat unauthorized scraping?
Well, for true threat actors that I keep talking about with unauthorized scraping, who are taking the data and using it to do bad things with it, there simply isn't enforcement mechanisms. And it's very difficult if you don't fit clearly into one of the hacking statutes or some of the others that we talked about to enforce against these actors. So having a way to do that, having a conversation with the global industry and community about how do we work together to do this and have mechanisms that we can even do something about this, I think is one part of it.
Great. Anyone else want to jump in?
Well, something it's not on web scraping, but on data scraping. The CFPB is doing something interesting right now and following in the footsteps of other countries in considering mandating that banks create APIs so that third parties can access user data through the API instead of scraping the data. This is for one, security reasons, because currently some banks, some third-party applications have taken user credentials to then go into the account, scrape the data. This is insecure. Giving your credentials to anybody is a terrible idea. And the credentials are at risk, and also the data can be misused. But also, the bank, the data provider doesn't have technical controls over what precise data the third party is taking. There's monitoring mechanisms, or they don't have the same kind of things. So it's a very interesting idea that perhaps one thing that can be considered in conjunction with proposing laws that ban web scraping is to, at the same time, mandate some kind of open access to data to ameliorate and to acknowledge the access interests on the other side.
And that's interesting because it's sort of an example of it's top down, but in any case, there's sort of there needs to be some way for those two actors, the scraper and the scrapee, to be on the same page as to what's authorized. I think that looking at that from a privacy perspective is interesting, because I feel like as we move toward that, even if they are on the same page, it may not be, it's going to be important to like to include in that proper notice and understanding for consumers
And control.
that that third party sharing is happening, right? Because right now it's unauthorized, so it's not, it doesn't really even touch from the privacy perspective. The controller is not sharing it to the processor directly, but then if they do have that relationship, if they through contract or through force of law are entering into this arrangement, the consumer is always going to need to be part of that equation as well, and that's something that will need to be navigated.
Yeah, I guess I would make a plug for research, which I suppose is what you would expect from an academic. But I think that it would be very important to understand the full scope of the problem and also its effects on cybersecurity. I think it would be very good if some of the federal agencies or Congress could look at this problem and say, what are the malicious actors? What are the harms that are resulting from leaving this practice essentially unregulated? Because I don't think that voluntary approaches are going to be sufficient. If they were, scrapers would just respect the robots.txt, that's already there that says, hey, please don't scrape my website. So I think that, there may be other ways to improve that. Don't get me wrong. I'm sure there are, with APIs and other mechanisms. But I do think there's going to have to be some kind of government action. And whether that can be done under existing regulatory authority, I think the Biden administration has shown there's a lot that can be done with existing regulatory and government authority without even having to get Congress to pass a law, or whether that's a law. We need to understand what the worst examples of this kind of scraping and what happens is. We need a decision, an explicit decision that, do we want companies like Clearview AI to exist? If so, what are the rules and oversight that should apply to them? How does this work in terms of policing reform, intelligence reform, and all of that kind of stuff? I worked for years inside the intelligence community on privacy guidelines and regulations. I can tell you, we worried a great deal about the intelligence community's access to publicly available information. Because of what was going on the internet. Yes, they can do it. Of course they can for valid intelligence purposes, but there's plenty of abuses as well that could be done through intelligence community access to that kind of data. So those are the conversations we need to have. More data, more research would help.
Great. Okay, lots of great ideas there, which I really appreciate. I see that we have a few more minutes left, and I think if we have any audience questions, I'll just pause right now and see if we have any. If we don't, I can continue. Yes, in the back.
Hi, I heard one of you mention the API and scraping issue, and you may or may not know. Hopefully,
Hey, we're bringing you a microphone because we do have a large virtual audience. Want to make sure they can hear you too. Thank you.
Okay, there we go. Beautiful. One of you mentioned earlier the banks and APIs and scraping, and I was curious if any of you are familiar with the CFPB's recent 1033 proposal, and whether if you had any reaction to their request for comment on the validity and possible uses of screen scraping.
Yeah, exactly. So I kind of brought it up in the context of the CFPB was doing this just like a few other countries mandating open banking. And yeah, we submitted comments recently encouraging the CFPB to mandate access through portals and to cut down on screen scraping for the privacy and security reasons. But if other people have any reaction, then.
Sorry, yeah, I was trying to formulate thoughts. Yeah, I think I would reiterate, I guess, again, that I think it really is a good example of a top-down approach that would try to create shared understandings of the relationships between the two parties. I think inherent in that also sort of that we were just teasing is this idea that I think there is some reason to try to figure out what legal remedies are out there and what paths to kind of having a stick are available, even if we create wonderful voluntary relationships, or through the CFPB or other specific agencies create these mechanisms where people are going to play well together. There needs to be some way to enforce that, right? There needs to be some way that if there are bad actors or small, now it's becoming increasingly feasible to do this type of, to create a company that does this type of work with very limited resources. We need to be sure that there's that those kinds of bad actors are kept in mind as we're thinking about possible solutions.
Right. And we had a question in the middle here, please.
Hi, my name is Tama. I've been practicing internationally for the past few years, and I'm right now here at Georgetown to sort of specialize in tech law and policy. So because my experience is more sort of international, one of the questions that I had, because you guys did speak a lot about, cross-border issues, one is that this exception that exists for publicly available data, because at least with the Indian government, I have engaged a lot, and there are certain reasons why there are certain kinds of people that they're trying to protect when they create that exception. But obviously, it does lead to this situation where it's very difficult to take action against unauthorized scraping. So when you say that a privacy law is the solution, I was wondering what kind of, how you would structure this. Would you want the publicly available exception to go away entirely and maybe have enforcement exceptions for, say, researchers? Or would you want the publicly available exception to stay, but maybe specifically for commercial use have some enforcement action built in, or say that it doesn't apply for that? So that's my first question. And my second question was, again, coming from basically an international background. One of the things that when we were advising clients, a lot of them were essentially doing these activities through subsidiaries in some corner of the country where it's difficult for governments to reach. And now in an increasingly globalized world where users are spread out everywhere, the actual companies against whom these acts are happening, like LinkedIn, etc., they might be maybe located in one particular place, but users are in different places. The government which is trying to reach them may not be able to reach them if they're in some other corner of the country, of the world, sorry. How do you think that that's something we can sort of figure out? Because that was very actively done by a lot of people who sort of came to us for advice, saying that, okay, this is where we are located specifically to, escape the reach of governments and enforcement action.
On the privacy law and whether there should only be only commercial use of publicly available scraped data should be regulated. I would point out that there are many harmful uses that are non-commercial, including some research that's done. A lot of the research that's going on. A decent amount of the machine learning type of work that's going on is done by researchers at universities. There have been ones, and I'm probably going to mistake it exactly what the research was, but it was scraped people's faces throughout the social media profiles, publicly available social media profiles, to try to figure out whether they were gay. And that was very concerning. But so yeah, it's not merely commercial use that's an issue. And I think if there's going to be exceptions, it should be perhaps more like giving the FTC or whatever privacy authority there is some kind of rulemaking authority and ability to make exceptions based on certain things.
I mean, just building on that, I think on this question of what's the alternative to having a publicly available exception, I think if that type of information is within the scope of privacy rules, it can come under the types of restrictions around purpose limitation, limitations for sharing, a kind of a more data minimization focused approach, where the secondary use, the use by the scraper, if it's not in keeping with the purposes for which the data was shared and collected, might go against the privacy law. But even laws like ADPA that start to have that sort of approach have also shown this publicly available exception. So
I have to say, I'm surprised, dismayed, and appalled at the research you're describing. It seems like it's an obvious violation of human subject guidelines.
You would think the IRB would have a problem.
The institutional review boards are required to review research involving human subjects. And of course, in 2023, human subjects don't have to be there physically. And that strikes me as being just an obvious open and shut case, but obviously that's not what they thought. Just one very quick point. I do think it's very important to sort of kill this idea that publicly available data could never be looked at because of the First Amendment. You know, all of our privacy torts that go back for 100 years involve publicly available data. You know, intrusion on publicity, intrusion on seclusion, and you go down the list of classic privacy torts where you can sue and get a remedy for that invasion of privacy. There's no publicly available exception to that. That would kind of gut the entire concept of those torts.
On the international question, I think that's exactly the issue. You have different countries approaching it different ways, and so people are going to one country to do it because they don't have laws on it, or they have laws. So India, you mentioned, has some computer laws, but they have hardly any enforcement in that area whatsoever, and so it makes it very difficult. So how we solve that, I think, is an ongoing conversation, but the point is there is a conversation that takes place, happens at a global scale. Maybe it's a Brussels conversation, maybe it's through coalitions. You know, there's a lot of ways to tackle it, but that's exactly the issue that needs to be addressed.
But ideally some coordination and some clarity. So we're at time. This has been a really fascinating discussion. Thank you so much, Chelsea, Cobun, Megan, Tim. Really appreciate you being here. Want to make sure we leave ample time for the break and the other sessions, which I'm sure will be equally fascinating. Thank you, everyone.
Wonderful to meet you. Obviously, we're working on some similar things.
Oops, thank you. As we transition to the next panel, it'll be virtual, so the screen will come down and we'll see our virtual panelists. But I just want to thank you by name. We had Julia Tama, a partner here at Venable, moderating. We had Megan Iorio, who is the Senior Counsel and Amicus Director at the Electronic Privacy Information Center. Chelsea Reckell, who's an attorney here at Venable. Timothy Edgar, who is a professor of the practice of computer science at Brown University, a senior fellow at the Watson Institute for International and Public Affairs, and a lecturer on law at Harvard Law School. We also had Cobun Zweifel-Keegan, who's the managing director here in DC for the International Association of Privacy Professionals. So thank you all so much for being here. Thank you.